Gender and law. Gender and law as an area and branch of law. Is a branch of law.
ওই রুমে থাকতো খাটো করে একবারে।
হ্যাঁ, মালয়েশিয়া ছিল যে।
হ্যাঁ হ্যাঁ, ওরা দুজন চলে গেছে
হ্যাঁ,
কোম্পানি ওরা কি করবে জানি না,
Contents of the lecture:
ওরা
how to
কাম কাজ
characterize
নেই,
this
ওরা তোলার
discipline,
মতো কাম কাজ ধরে নেই,
can we
যদি
speak
তোর
about
আইনি কোনো
on
সহযোগিতা
gender
লাগে
and
সেটা
gender
আমি
law?
করে
না
দেবো।
সহজ
Is law and
মুখস্থ কথা নাই,
gender law
এটা
gender
থেকে দিতে
law
গেল
and
চলে আসো,
your
সমস্যা নেই।
branches Serbian friends, US
মানে
citizens,
সহজ করে বলি,
including
এবার
assessment.
তো টিআরসি হয়, এনওসি
পাসপোর্টের
দিবি কে?
Unpacking law gem. Unpacking the law gem acronym and the relation between law and gender should be labeled the discipline. Unpacking should be the label the discipline law on gender, oblique gender law, akin law on contracts and torts on criminal law, law on gender akin law on society and law on religion. Conceptually, it is not inconceivable to have two disciplines, e.g., for example, law and economy and economic law. Why characterization matters? From a personal perspective, it matters whether one is a specializing in some subject of study or b broadening its scope. Broadening scope. From a perspective of an education institution, an organizational form of the knowledge transfer should ideally match the character of the discipline, is for summer school versus master. From a perspective of a respective professional community, potentially makes a profound difference if it is professional organization is picking up gender lawyers.
আচ্ছা, আমাদের আচ্ছা, আমাদের আমাদের যে হলো
What tax is it? State less directly contributes to the systemization of various local provisions into
আচ্ছা, আমাদের
into distinctive disciplinary units by drafting central pieces of legislation, is for example, criminal or the civil code,
আচ্ছা, আমাদের
criminal versus civil code, or by providing institutional division level, is for example, administrative constitutional code, it plus
আচ্ছা, আমাদের আচ্ছা,
plus it may prescribe which disciplinary areas shall be passed at the bar exam. Law faculties affect the solidification of various disciplinary fields through the curriculum design. Not only does this pertain to the very organization of certain courses, but also to their status in the curriculum. Plus, often there is overlap between the compulsory courses and the disciplinary areas covered by the bar exam. Legal service science of scholarship, the one which the relying on the aforementioned factors as well as on relevant developments in the legal doctrine, tries to provide the most comprehensive analysis of putative constitutive parts of a legal system. Luke is on systemization of law. Legal system is logically ordered and non-contradictory set of norms, general legal norms, which all adhere to each other and depend on each other. When bottom-up ordered, the elements of the legal system are legal concepts, a set of legal provisions that refer to one and the same social relationship, easy, for example, inheritance, adoption, negligence, etc. Legal branches, a set of civil legal concepts that regulate a number of related types of social relations according to the same principles, for example, family law, criminal law, consumer law. Legal fields, legal branches are grouped into them according to the common characteristics stemmed from the unifying principles, civil and international law, public and private law, material and formal law, and the state and autonomous law. Families of families of legal system, common law, civil law, and Sharia-based law, upon which category to characterized law and gender law would be the only more than a legal concept, and they're less than a legal field. Khotian, Khaitan, and still theoretical framework employ the term area of law. Lukis branch of law. They argue that an area of law is the area of law. Other the area of law is a subset of the legal norm and subjectivity. Equals by legal complex in the system is a subset of subset of as a subset of such norms. While one seems they rather obvious, two is in the need of further clarification. There are rules of that an area of law is a subset of legal norms in the system, which is number two, which is intersubjectively recognized by the legal complex in their system as a subset of such norms. While one seems rather obvious, two is need for further clarification. Recognizing something as an area of law. Recognizing of an area of law has to be based on something additional than mere existence of certain subject of legal norms. For instance, Sunday law is now where recognized as an area of law. As an area of law, even though one may find bunch of legal a bunch of legal a bunch of legal provisions that regulate activities on Sunday. Easy, for example, require all elections to be taken on that day, or forbid shops to be open on that day. So finding a word gender in some legal provisions no does not necessarily amount to recognizing something as an area called law and general law.
কি রুটি নিয়ে আসলেন? কিনে আনলেন না রুমতে আনছেন? রুমতে আনছেন এখানে ছিল যে রুটি এখানে ছিল আমার কাছে। আরে ভাই এইসব দিয়ে খাইয়ে জমাতে ভালো লাগে, একা একা ভালো লাগে। একসাথে দুই একদিন হলে একসাথে করে খাইতে খুব মজা লাগে। ক্যাম্পাসে গেছিলাম না, যেমন সাদা করে নিয়ে গেছিলাম বেশি লাগে না। সকালে তো অনেক সময় দেখা যায় যে মেয়েটা দেরি করে, অত রুটি পাওয়া যায় না, না খেয়ে দেওয়া লাগে। দেখা যায় টাকা পাঠিয়ে টাকা পাঠিয়েছেন বাসির বাড়িতে। আমি তো জিজ্ঞেস করলাম আমার আগে পাঠিয়ে দিয়ে বলে আসে বললাম কাছে দেখে দিচ্ছি, কাছে দেখে দিচ্ছি।
भाई साहब ये मेरा भाई भाई साहब नेपाली नेपाली और नेपाली ना
The role of
আমি একলা বাইরে লইছি
the
আর
legal
কেউ নাই তো
profession
কেউ
collectively
তো আনন্দ না আনন্দ না
comprising
সবার
legal
ডিউটি
editors,
মিউটি লয়ে থাকবেন না ভাই
presenting, judging, prosecuting, teaching, and writing law. Professions can include judges, legislators, legal academic, private lawyers, civil servants, law reform movements, legal services regulators, law commissions, legal advisors, academic publishers, conference organizers, law journal editors, legal consultants, court registers, casebook and textbook writers, case reporters, and the like. What is intersubjective recognition? Intersubjective recognition amounts to the recognition of something as an area of law, which occurs across different aforementioned sectors of the professional community of lawyers. That is, areas of law are
সকালে তো
subjective,
টাকা টাকা দিছি।
intersubjective phenomena in themselves, that their existence depends on shared acceptance in the consciousness of at least a subset of persons comprising the legal complex in a given society. A curious position of legal science-based scholarship. While it is best equipped to perform the analytical tasks of systematization of law, it has to rely on the legal practice. Legal depends on the regulation. It is position of the legal science-based scholarship, while it is best equipped to perform the analytical tasks of systematization. Why it is best equipped to perform the hierarchical equilibrious position of legal sense of scholarship. While it is best equipped to perform the analytical tasks of systematization of law, it has to rely on the legal practice of doctrine, and its success depends on the recognition of by other parts of the legal complex. And yet, nothing prevents legal scholarship to try and to inaugurate an area of law by developing a classification system of norms that is not already in existence. Possible criteria of systemization. The regulatory object, the specific object of legal attention is the most common basis for delineating areas of law, a type of person, entity, refugee law, company law, family law, and a type of relationship, employment law and tenancy law, a social activity, banking law, construction law, an event contact law, a category of things, antiques law, food law. Regulatory purpose. Some areas of law are defined by the regulatory purpose they seek to achieve. Anti-discrimination law seeks to eradicate discrimination. Consumer protection law seeks to protect consumers. Regulatory procedure. Some areas of law are identified in a self-referential manner by reference to law's own procedures, legal remedies, or enforcement mechanisms. Easy, for example, criminal, civil, administrative law procedure. Is law on gender an area of Serbian friends of the US etc. law? One, is enough there enough law legal material, legal provisions, pieces of legislation, court jurisprudence, courses at the law faculties, conference college, etc. that enable us to parcel out something as a distinctive area or branch of Serbian law on gender or gender law. Serbian gender-related law legal material. When it comes to the pieces of Serbian legislation, the most important one are 2021 Gender Equity Act. Gender equity implies equal rights, responsibilities, and opportunities, and equal participation and balanced representation of women and men in all areas of social life. Equal opportunities to exercise rights and freedoms, use of personal knowledge and abilities for personal and social development, equal opportunities and rights in access to goods and services, as well as achieving equal benefits from the results of work while respecting the biological, social, and culturally formed differences between men and women, and the different interests, needs, and priorities of women and men when adopting public and other policies and deciding on rights, obligations, and provisions based on law, as well as constitutional provisions. Article 3. Serbian gender-related raw legal material, Article 6, which contains limited legal provisions differentiate between gender and sex in the following way. Gender means social roles, opportunities, behaviors, activities, attributes. A certain solution considers appropriate for women and men, include the mutual relations between men and women and the rules in those relations that are socially determined depending on gender. Sex is a biological status on the basis of which people determine as a man, woman, or man. Have generated raw legal material. An equally important piece of legislation is the provision of Discrimination Act 2021, which is civil, social, especially gender-relevant provisions. Discrimination exists if it is acted against the principle of gender equality, that is, the principle of respecting the equal rights and freedoms of women and men in political, economic functions and other aspects of the public, professional, private, and family law, like denial of rights or public or convert. Denial of rights or public or convert recognition of benefits in relation to sex and gender identity or due to sex change, that is sex adjustment to gender identity, as well as pregnancy, maternity leave, or for child care, or especially child care is prohibited. Physical and other violence, exploration, expression of hatred, belittling, blackmailing, and harassment with regard to sex and gender identity, as well as public advocacy, support, acting in accordance with prejudices, customs, and other social patterns of behavior based on the idea of gender subordination or superiority or stereotypical gender roles are prohibited. Article 20. Serbian gender legal legal material. Register of Births Acts 2009, amended 2014 and 18. Article 45 will be stated that in the register of births, if the change of sex is entered based on the decision of the competent administrative authority, which is adopted on the basis of prescribed certificate of the competent health institution. Certificate in point shall contain the following data: name and surname, date, place, municipality, city of birth, identification number, name and surname of parents, person whose sex has been changed, information on sex change for that person, as well as name and surname of the doctor who issued the certificate. Serbia generated raw legal material. The legislative change came about as a result of the 11 groundbreaking decision of the Constitutional Court of Serbia, in which it stated that constitutional appeal of acts is approved and it is established that municipal administration or municipality jet, by reaching conclusion of actual lack of jurisdiction, failed to decide on the request of the applicant of the constitutional appeal to change data on sex and thus violated his right to dignity and free personal development guaranteed by Article 23 of the Constitution of the Republic of Serbia, as well as the right to protect respect for private life guaranteed by Article 8 of the European Convention for Protection of Human Rights and Fundamental Freedoms. Moreover, the court stated that according to the then varied version of the Registry of Births Acts, administratively competent to decide on the the municipal administration and the municipality of JED are ordered to, within 30 days from the date of delivery of the decision, decide on the request of the applicant of the constitutional appeal to change sex data in birth register. Serbian generated law legal material. As for other significant aspects of the legal complex, the record regarding as the science of recognition of law and gender, and as a distributive branch of law, is rather mixed. Legal practice is rarely, if ever, referring to this new area of law under this level. The only course offered so for the Faculty of Law, University of Belgrade, is offshore, is Discussion Studies. It is conceived as a broader interdisciplinary course whose goal is raising awareness on the importance of gender-sensitive understanding of laws and legal education of gender mainstreaming in the higher and legal education. Concluding assessment. Studies in gender law in are a peculiar disciplinary state of flux. A significant part of Serbian legal scholarship at the Faculty of Law, University of Belgrade seems to take steps in the direction of integrating an area of law by developing a classification system of norms that is not already in existence. It is also so by accrediting a master program whose preparatory activity is its spring school, by organizing national and international conferences on this topic, by publishing books on this topic with a book local and prominent international publishers. Easy book series with Springer. The ultimate success of this endeavor will depend on the intersubjective recognition of this area as an area of law by the critical mass of actors in the relevant legal complex. It seems that no such critical mass exists yet, while there is enough raw legal materials within Serbian legal system to work with. No circle of lawyers who would think of themselves as gender lawyers has emerged for so far.